Hey guys, what's up? George for Title, Inflation.us. I don't know if you can see behind me. Typical U.S. bank, a foreclosed, beat to hell property. Now here's the situation. I've been getting reports in Southern California of illegal practices by U.S. Bank. Now I'm not saying that U.S. Bank has broken the law, but there's a lot of practices going on in the lending industry and in the foreclosure process that does raise a lot of eyebrows, mainly this one right here. So this is the discovery process of something that could be pretty damn sinister and that affects a lot of people across the country. So anyways, the question that we need to ask is U.S. Bank a legal entity in California? In this gentleman's countersuit in the foreclosure process, he didn't know who to serve, because there's a question between whether you're suing U.S. Bank, which is on all the bank buildings, or U.S. Bank Corp, because U.S. Bank is saying, well, U.S. Bank Corp is our legitimate company, but don't sue us, sue U.S. Bank, which according to this gentleman isn't even listed on the Secretary of State. It's not even an actual entity.
Well, here's the actual document from the Secretary of State, and it says they checked the box. This is one of their forms. Is not of record in this office as either a domestic or foreign entity. So we don't know who to serve. We know who their lawyers are, so we gave them the documents, but they're not listed with the Secretary of State, which they're required to do if they're going to operate in California.
U.S. Bank is the 6th largest bank. They are a huge recipient of TARP funds. They've got over $7 billion. The banks could be possibly violating the Truth in Lending Act with giving full disclosure in two ways that the banks have been possibly breaking the law. In the lending practices, when people were getting these loans, and the foreclosure process. And we're talking post-foreclosure process. Things that the banks may be doing wrong. So let's get to it first. Let's talk about the lending practices, easy money.
Yeah, well, when most of these people a few years ago were getting the loans, they were just loaning out money without any proof of income or a stable job, or you could just say you were making $100,000 and they give you a $500,000 loan, and so these loans were given to people that they were sure at some point they were going to probably have default on them. And then, of course, the interest rates rose, like they reset. And so now, some of these people's payments have doubled. So, that, they're going to lose the home.
Number one thing that the banks may have done wrong is verifying income. A lot of people understand that the banks sell their mortgages to Fannie Mae, Freddie Mac on the secondary mortgage market. Did the banks verify the loans, or did they just give away the easy money and fraudulently sell those loans on the secondary market? That's a question that I think we need to ask. Is that fraud when a bank knows that this person isn't making $100,000 a year, but they give them the money anyways and they sell it on the secondary market?
Yeah.
Is that more? It's morally not right.
Yeah, but is it even legal?
Is it even legal?
Yeah. And where did all this money come from?
We're talking about basic accounting here, guys. Where did you get the money to loan these people? If the bank was injured, meaning the bank was injured in some way, they need to show us how they were injured. They need to show us the accounting of where they got the money from to loan these people in the first place. That's the question.
They're reluctant so far. They haven't supplied anything.
And then this has been covered in the news a lot. The whole original note holder, show me the note movement. And you're saying this is valid, meaning to foreclose and to get legal title, U.S. Bank needs to produce the original note. What happened to the original note? They're not producing them. Were they shipped overseas? Are they sitting in the Federal Reserve in some warehouse? But what you're telling me is for a bank to foreclose and to take back a property, they need to show the original note.
Yeah, we were discussing this earlier. You could have a Federal Reserve note and you can copy it in a copying machine, but you're not going to be able to pass that copy as an original. So whoever's holding that original note is the person that should be foreclosing and should be handling all the legal issues. If U.S. Bank isn't the holder of the note, they don't have a rightful title and rightful claim to anybody's property.
Now, guys, we're talking about the foreclosure process. This is post-foreclosure. We're not even talking about the 3 months and 30 days or whatever, 21 days, whatever it is to foreclose. We're talking post-foreclosure. The bank has already foreclosed on the home. The former homeowner is still living in the home. Now, what happens? And what this gentleman here is saying, they're using a legal mechanism called an unlawful detainer, which is typically used for renters. And there's a couple questions that you have with using an unlawful detainer. Number one, it's very fast, it's very efficient, but you should have the right to a trial jury under an unlawful detainer. And if you have any interest in a property, they shouldn't be using an unlawful detainer. Meaning interest is, you know, the 10 or 20,000 or 30,000 you may have poured into the mortgage already. That's an interest. Am I getting this right?
Yeah. And in the unlawful detainer law, it's in California. It's California Code of Civil Procedures 1172. It says if the defendant can show he has a defense and possession of the property for a space of a year, that such showing is a bar to the proceedings. In other words, they should be suing you in civil court and not using the unlawful detainer process.
And the reason they don't want to sue you in civil court is because
it would take years. You know, they couldn't just get you out on the street. Unlawful detainer usually only takes maybe 30, 60 days, whereas if they tried to sue you to force you out, it might
take 3 or 4 years.
Yeah.
So that's another question that we have about the banks. They're using something called an unlawful detainer to kick people out, but usually that's reserved for renters.
Right, and in this process, after they had foreclosed on the home and they started the unlawful detainer action, they actually entered what they considered a rental agreement, but he had never signed it and had never seen it. And it was basically they were charging him so much per day for renting the property now.
So they're actually producing documents saying you're a renter that you haven't even signed.
Right. Yeah, it's their property and they just came up with a figure for the rent that they think that the house is worth.
This gentleman that I'm talking to, who's gone through the process of helping 2 people out, he's noticed that there's an interesting dynamic happening with these banks taking over these properties. I kind of detailed it in my notes. But in one particular case, Pomona First Federal owned the mortgage. Okay, somehow that went back to the FDIC, and then it went to auction, and then it went to U.S. Bank, and U.S. Bank then sold it to a third-party investor. Now here's the interesting part. U.S. Bank is saying that they bought the property from the FDIC for $100,000, and they sold it to a local investor for $32,000. Then this local investor goes after the former homeowner to get him out of the house. Now here's the question. How can a bank be in business buying houses for $100,000, selling them for $32,000, buying houses for $100,000, selling them for $19,000? They could have taken the original house and just sold it to the original owner. Does this sound like a proper business plan to you, where a bank is buying property from the U.S. government for $100,000 and selling it for $19,000 to a private investor? To me, that sounds like a terrible business plan. And so what's your comments on that?
Well, yeah, that's the part of the reason why we want the accounting, because how is the bank, they supposedly paid back those TARP funds, and how are they making a profit? You know, I mean, where's all this money coming from? Where did it come from originally? And then where did they get the money to buy it from the FDIC? It just doesn't make sense. So we just want, you know, a CPA accounting of the bank. They obviously have accountants. I mean, they're supposed to have really good books, but, you know, just show us the accounting. And that's part of the Truth in Lending Act. It should be made available. Well, I just think that they're bending the rules a lot for these banks, and it's hurting the people. So I think at this point we're asking questions, and it seems they're not forthcoming with their answers. So I think this is, you know, everybody out there listening to this, they either are in a situation like this or they know somebody that has been. And at this point, I think we just need to, like, twist these people's arms a little bit